Most Australian states and territories manage asbestos in a similar manner. In the past, much of the statute law has focused on workplaces and the commercial sector through occupational health and safety acts and regulations. But more recently, asbestos risks have become a public health issue, with state and local authorities moving to address issues in the home and other non-workplace environments. In this section, we'll look at some items of legislation and regulation and the obligations they impose. This is the Code of Practice for the Management and Control of Asbestos in Workplaces. It supports the national prohibition on the use of all forms of asbestos. However, this prohibition does not require the removal of asbestos which was already in a building when the prohibition came into force. The Code recommends the removal of asbestos-containing materials where practicable. Accordingly, consideration should be given to the safe removal of ACMs through renovation, refurbishment and/or maintenance in preference to other control measures such as enclosure, encapsulation or sealing. Anyone with control of a premises has a duty of care to do a number of things related to asbestos. They must ensure that a competent person investigates the premises for the presence or possible presence of ACMs. And they must develop and maintain a register of the identified or presumed ACMs, with details of their locations, accessibility, condition, risk assessments, and control measures. The competent person must assess the condition of any ACMs found on the premises and the associated asbestos risks. They have to develop and implement an asbestos management plan. This plan must be reviewed every 12 months or earlier where a risk assessment indicates the need for reassessment or any ACM that has been disturbed or removed. Develop an action plan or remove the ACM or minimise the risk some other way to prevent exposure to asbestos. And ensure the control measures are implemented as quickly as possible and remain in place for as long as the ACM remains in the workplace. Install warning signs and labels to identify ACM at a workplace. As with all health and safety issues, consultation is important. Make sure everyone involved, employees, contractors, tenants and building managers are aware of the ACM issue. And make sure that everyone who could come into contact with the ACM is adequately trained, so they won't inadvertently disturb the material. In Queensland, building owners have a statutory obligation to implement the above responsibilities for workplace buildings constructed before the 1st of January 1990. In addition to the requirements under the Management and Control Code of Practice, a separate Code of Practice sets down procedures for handling asbestos. These are set out in the National Code of Practice for the Safe Removal of Asbestos, 2nd edition. This code requires that asbestos removal is undertaken by an appropriately licensed person. In Queensland, there are two types of asbestos removal licences, A-class and B-class certificates. A-class certificate covers all types of asbestos removal work, any quantity of friable ACM and 10 square metres or more of bonded ACM. Is held by the business that undertakes the removal work, and a competent person must directly supervise all asbestos removal work. B-class certificate covers work to remove only 10 square metres or more of bonded ACM, does not permit the holder to remove friable ACM, is held by the individual worker. Each worker who removes or is directly involved in the removal of bonded ACM must hold a B-class certificate. An asbestos removal control plan is developed and agreed to before removal work starts. Regardless of the quantity of asbestos to be removed and the licensing requirements pertaining to each state and territory, all asbestos removal work must be performed in accordance with the National Code of Practice for the safe removal of asbestos. The boundaries of the asbestos to be removed must be determined, and the area protected by signs and barriers. During removal, appropriate asbestos, high-efficiency particulate air HEPA filtered dust vacuum cleaners should be used, and appropriate personal protective equipment, including respirators, must be used. And air monitoring should be undertaken to ensure control measures are effective. In Queensland, written air monitoring programs must be developed by a competent person for all indoor removals of friable ACM and for all outdoor removal of friable ACM where there might be a risk to other persons. When removing bonded ACM, air monitoring requirements should be determined on a risk assessment basis by a competent person. Following asbestos removal, the workplace, equipment and tools and personnel must be properly decontaminated. The waste must be appropriately contained and disposed of at an approved landfill. And after the removal work, a clearance inspection must be undertaken by a competent person independent of the removal work to make certain the asbestos removal work has been completed and there is no visual evidence of dust and debris. Depending on the nature of the work, clearance monitoring may be required at the completion of the removal work to ensure the airborne fibre levels are consistent with normal background levels. Under current Queensland workplace health and safety legislation, the provisions of these codes of practice become mandatory in Queensland workplaces. This means you can be fined for any breaches of the requirements of the codes. The Public Health Regulation 2005 covers non-workplace areas, including private homes. Under this regulation, no one is permitted to remove friable asbestos or more than 10 square metres of bonded asbestos unless they have the appropriate asbestos removal licences. They must not use power tools to clean or cut ACMs, nor use high-pressure water or compressed air for cleaning ACMs. Broken ACMs must be sealed. They must take reasonable measures to prevent the release of asbestos fibres and must double bag or double wrap ACMs. Finally, selling or giving away ACM is forbidden.